So friends, the concept of burden of proof refers to the duty or obligation on a party in a legal proceeding to prove the facts that they assert in order to succeed in their case. So if I am asserting a certain fact, then I'll have to, it's my duty to discharge the burden of proof and in this legal proceeding. So now the question arises that who has to prove what and to what extent. So the burden of proof actually determines that who must produce evidence, what they must prove and how convincingly they must prove it. So it is essential in both the civil and criminal proceedings. So there are two types of burden of proof. Now the two main types are the legal burden and the evidential burden. So the obligation to prove a fact in issue to the required standard is a legal burden. For example, in a criminal trial, the prosecution always bears the legal burden to prove the accused guilty, and so likewise in evidential burden, the obligation to produce some evidence on a particular fact enough to make it a real issue for the court. So this burden can shift between the parties during the trial. For example, if an accused raises the defense of an alibi, that they have the evidential burden to produce some proof of being elsewhere. So here the legal provisions which is which shows the concept of burden of proof is that in the Indian Evidence Act 1872, it's a section 101 to 114A. So here section 101 says whoever desires the court to give judgment in their favor on facts they assert must prove those facts, and section 102 to 114A explains who bears the burden in different situations and where it shifts. So here presumption is also one of the major concept in this particular thing. So we are not going into the presumption, but the main key principle which we have to keep in mind is that he who asserts must prove. Now if somebody is asserting a particular fact, will have to prove it initially. A party making an allegation must back it up with evidence. Now if a party has discharged his or her liability by giving a proof, then it becomes the burden shifts to the other party. The other party will have to now give the proof of their defense. So or they have to negate the particular fact in this in a particular case. So in criminal law, the burden is mostly on the prosecution, and in civil law, the plaintiff bears the burden initially, but it can shift based on the evidences and the defense. So here now in example, like A sues B for non-payment of a loan. So a plaintiff must prove that the loan was given